Welcome to Absolute Trust Talk with your host, Kirsten Howe. Absolute Trust Talk brings you tips, tools, advice, and interviews to help you build a reliable knowledge base on estate planning, business, and finance to start preparing for your future today.
Hello, everyone, and welcome to Absolute Trust Talk. I'm Kirsten Howe. I'm here with Madison Gunn, and this is another episode in our little mini-series called Character Matters. And if you didn't catch the first episode, it's short. You can go back and listen to that if it helps you understand this one. Basically, we were talking about the difference between community and separate property and some of the reasons why it matters. And now we're going to kind of focus in on why it matters to us as estate planners and therefore why it matters to our clients. But, you know, kind of what we are looking for and what we are concerned about when we're planning with people who have both community and separate property. Madison, what would you say is the biggest lesson, the biggest takeaway here when we're doing estate planning?
Yeah, and why it matters so much to us and why we're nitpicky and annoying about driving the point home is that you can't give away what's not yours. So if you have community property, your spouse is entitled to half of that, and you can't give that other spouse's half away. That's their decision. So we've seen this where in this situation, it wasn't like anything untoward. It was like an accident.
It was an accident.
But sometimes people will say, I want my kids to have my entire IRA. I don't want it to go to my spouse. But if that IRA was from earned money during your marriage, there's a community property interest in it. And you can't give away your spouse's share of the community property or their half of the IRA. Right. Obviously, that can get very complicated. We're just going to stick with the high level conversation about that because we don't do the math that family law attorneys do to figure out exactly how much interest everybody has. That's not math we do. We just need to make sure things add up to 100%. So that's the big part that we are concerned about.
Right. And I mean, an important point to sort of infer from that is this is not just important in terms of how we write a trust or a will. There's lots of other ways that people leave assets or give assets to people. So there are IRAs, there are life insurance policies. You cannot make somebody other than your spouse the 100% beneficiary of a life insurance policy. If that policy was paid for with community property, your spouse owns 50% of that death benefit.
What if you have a bank account that's just in your name and you put a beneficiary on it? But that money was your income during your marriage.
Your wages. Yeah, same thing. So this can present itself in all kinds of contexts, not just when you're sitting in your attorney's office planning out a trust or a will. But that's what we do. So we're going to talk about that too. We have clients who will come in and say, you know, this is really funny to me. I've said this many times before, second marriage, and they come in to do estate planning together for the first time because it's so common. They've been married 8 to 10 years. That's the time frame that I see literally, you know, half the time when a blended family is coming in. It's like, okay, I guess this second marriage is going to work. Now we'll do estate planning. So they come in, oh, I had this when we got married. I had that when we got married. And now we have this together, you know, separate community. But as we talked about last time, it's not that clear.
People will come in and tell us what their community and separate property is. But unfortunately, as we discussed in the first episode, the character is something that's born by its definition. When you acquired it, how you acquired it, that determines whether it's community or separate property. Not you, unfortunately. However, you can change that character. So you do have the option to do that. Not in our office.
Right. We don't do that. So changing the character of an asset, in other words, pointing to that asset and saying, this is my separate property, but I want it to be community property. That's called transmutation. Transmutation means change.
Right.
And you can do that. First of all, it has to be in writing. It has to be in a writing signed by the person who is impacted by that. So if you're changing your separate to community, the person whose separate property it was is the one who has to sign it. If you're doing the opposite, going community to separate, then both spouses really need to sign that. But anyway, so you can change it. And sometimes that makes sense for tax reasons or just for marital reasons. You know, you want that for your spouse.
But when it comes to more than just one piece of property, because that, you know, one asset or one piece of, typically we see it on a house.
It's on real estate.
That's typically where we see it on real estate. And the language has to be very explicit on the deed or whatever you're doing to change the character. and signed by everybody. So it's not something that you can just put in both your names. That doesn't just make it community property.
Community, right.
That's not how that would work. You have to have explicit language on there that says this is a transmutation.
Right.
So that's how that would work. And that word is very specific too. One of those legal terms. However, if you're changing all of your assets or you're confirming what is separate, what is community, this is how we've been treating it, but we want to make sure that this is how it stays. You have to do either a prenuptial or premarital agreement prior to marriage, or you can do a postnuptial or postmarital agreement after you're married.
Right. So a prenup could say something like, this list is my separate property. This list is your separate property. And we both agree that no matter what happens, it doesn't matter who pays the mortgage, who pays the property taxes, who pays for the new roof on the separate property, it will remain our separate property. You can have an agreement like that.
It can say my income stays my separate property.
Yeah, you can agree to all kinds of things that are different from the law. And so you can do that in a prenuptial agreement, or you can do it in a postnuptial agreement.
Right.
If you didn't have a prenup, but now you see the value in doing that, which is typically because your estate planning attorney is telling you need to do this. I mean, that's where we really engage a lot with the family law attorneys. Because why do we use family law attorneys for this, Madison?
Because how you do a prenup or postnup, first of all, both are wildly different in terms of procedure. A prenup and a postnup are different. And we don't know what the procedure is because it changes. Every time there's like major court case or a major divorce case that goes to litigation, that procedure might change a little bit. When I was in law school, there was like a 7-day waiting period prior to getting married. You could not basically force someone to sign a prenup the day of the wedding or the day before the wedding. There had to be a waiting period. Right. I'm sure there still is, but I don't know what, it changes. So the family law attorneys, that they have to be involved. They have the expertise. They know the family law code and they know the case law because that's their area of the law. That's not our area of the law. So we team up with them when we need a family to have a postnup. It's usually a postnup that we're insisting upon, and they do it and they do it right. Because if you don't do it right, it's not going to be enforceable. Right. There's all kinds of disclosures where you have to, let the other spouse know everything. There's all kinds of little procedures that have to be done. And I think everybody has to have their own attorney. And if you agree to use one attorney, there's probably extra procedures to make sure that agreement is solid. Yeah. So they're all things that we don't deal with on a daily basis. So we use family law attorneys to bring them in. Just as they would not be writing your will. The family law attorney is not going to write your will. They're going to call us. So everybody has their own little niche. Our little area. Yeah. And we stay in our own sandbox. We don't try to jump into anybody else's. We have to know a little bit, right? We have to know community and separate to explain it to clients. We have to know enough to know that we don't want to commit malpractice and get our clients in trouble. We don't want to write a trust that they don't have the authority to give those assets away. And then there's litigation because we don't do that either. Right. It's all about really making sure it's smooth after you're gone. So you've got to get the correct documentation in place. Anything else we want to say about that? No, I think it's just important that as much as we all want to say what's community or separate, you don't get to arbitrarily decide. Or even if it's not arbitrary, you're like, I inherited that, it's mine, it's 100% separate property. Are you 100% sure? And if you're not, you should have an agreement with your spouse in writing. Mm-hmm. And most of our married couple clients have a joint revocable trust. Mm-hmm. That's their main estate planning vehicle. But we do have quite a few clients who one spouse or both spouses have significant separate property and they want to keep it separate. And so those families will have wife's separate property trust, a joint trust, and husband's separate property trust, one or two of those three. But so that's not unusual. Keeping things separate is often a good thing. Yeah. And it might be that they don't need a prenup or a postnup. They just, okay, my parents died. I'm going to inherit $1 million worth of assets. Let me set this separate property trust up to receive it. The spouse's name's never been on it, nowhere near it. Obviously, you still have to worry about if you're mixing, but if you have $1 million in assets, then it's probably generating some income to pay towards if there's any type of expenses. Yeah. So, but if you're able to keep all the separate, obviously commingling is where that's going to be a big problem. But again, not a 50-50 problem, just an interest problem. Right. It's not uncommon for us to have had to engage family law attorneys or forensic accountants to try and figure out how to pull things apart. So, we've had to do that. We've had that scenario where the stepchild and the step parent now own a house 50-50. And how are we going to deal with that?
How do we make that work for the family? Okay. That's a further lesson in the community property versus separate property character matters world. And thank you all for joining us. I hope you learned something. Madison, thank you. And we look forward to connecting with you next time.
Thank you for joining us today for another episode of Absolute Trust Talk Live. If you enjoyed listening in, then don't forget to subscribe. You can find us on Apple Podcasts or wherever you may listen by searching Absolute Trust Talk. While you're there, we would also love for you to leave us a review. And then why not share your favorite episodes with family, friends, or colleagues too? You can find all of our shows and corresponding show notes by visiting absolutetrustcouncil.com. You'll also find a variety of other free resources, including our ebooks, videos, blogs, presentations, and more. If you need help with your estate planning or administration, we also offer a free discovery call to help get the process started. You can find more information on booking your session by visiting absolutetrustcouncil.com/scheduling. If you join us for the broadcast, you can submit questions during the show. But if not, don't worry. You can always get in touch with us by sending a quick message to info@absolutetrustcouncil.com. Thanks again for listening. We'll see you soon.
This podcast is not meant to take the place of legal advice from an attorney and does not create an attorney-client relationship. If you do have a legal question or issue, please consult with an attorney.